So this is section 11 petition seeking appointment of arbitrator. I'm requesting, Lord, I've come from outstation. I'm requesting if it can be taken up at some specific time, subject to your lordship's convenience. Today.
2 p.m. second half.
2 p.m. Deeply obliged.
Lordship, I beg to mention item number 62, bail hearing matter, Lordship. I have informed the other side, Lordship, we have not received the CD today, Lordship. Kindly fixed it on 8th of April, Lordship.
Bail hearing.
Lordship.
Item
Item 62, Lordship.
Item 62. At the request made by the learned deputy, matter stands deferred to be listed on 8th.
8th of April.
8th of April.
Please, the Lordship. Lordship, I beg to mention item number 32, Your Lordship. In item number 32, we need to take instruction, some instruction, Your Lordship, regarding his appointment, Your Lordship. That instruction is not getting, and we have sent the communication to the person. Your
Item
Lordship.
32 at the request of counsel for petitioner stands adjourned for 3 weeks.
May I please address? Okay, for listing and admission matter, area salary regarding area salary, next week any date, Your Lordship.
Next week, let it be after the vacation. Next week.
Next any date. Except 8, 9 Your Lordship.
Second.
Second.
Your Lordship, similar prayer, Your Lordship, 2017 minutes.
Yeah, please, same meter.
Second.
Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 7, Your Lordship. I'm praying for an adjournment in this matter. Learned Counsel P. Deca is having some personal difficulty today.
Item 7 at the request made on behalf of Mr. P. Deca, matter stands deferred to be listed after 3 weeks.
After- Obliged.
May I please? Lordship, I pray for listing of matter from motion, Lordship, urgent matter, Lordship. I'm filing it today.
Second?
Lordship. Lordship,
2nd April.
Lordship, can it be on first? Because Lordship, otherwise he may be the officer is a assistant commandant in BSF. He may be discharged at any moment, Lordship. On first. Lordship, I'm filing it now, Lordship. I have not
All right,
filed it.
first.
Yeah. All right.
Pray for listing of an higher for inflation of on motion matter. On
Second?
next-
2nd April.
Already 1 month is completed. I have filed it. Till today, that application was not before this one.
2nd April.
7 April matter. Obviously,
May I please, Lordship? I beg to mention for listing in today's list, production list, urgent matter.
What matter? What urgent?
Transfer. He have to join on 1st April.
Let him join. There is no urgency in transfer. Let him join.
But the transfer process is done without following the norms.
Whatever it may be, you are challenging the transfer order.
Yes,
Let him
sir.
go and join. His joining will
He-
not
He
be
is transferred to Thiruvananthapuram, Your Lordship.
whatever it may be. It's a transfer order. When was the order taken out?
13th,
13.
yes,
Of
this month, March.
13th has been quite some time now. What were you?
Means I have made a representation to cancel my transfer.
No. Let it be on first of
First,
April. Yes.
Okay, victim is item 53, Lordship. The engaging counsel DA Kaim is out of station, Lordship.
53 at the request made on Mr. D.A. Kaim.
3 weeks.
Council stands adjourned for 3 weeks.
Obliged.
Yes, please, Your Lordship. I am praying for listing for withdrawal, Lordship. 1st April.
First April.
May I please, Your Lordship? I beg to mention for withdrawal. The matter may come on Tuesday.
First April.
Deeply obliged.
May I plead your Lordship, with the consent of the other side, Lordship, I beg to mention item number 37, Your Lordship. Lordship, kindly matter may fix after Bihu vacation, Your Lordship, if possible, Lordship.
37.
Lordship.
Yes. 37 at the request made by the learned counsel to the respondent. This after 3 weeks.
I'm obliged,
May I
Lordship.
please, Your Lordship, I beg to mention for petition for admission, Lordship,
For listing,
Listing.
let it be on 20. On 11.
11.
Yeah.
Lordship, I'm praying for listing of a matter for admission, Lordship, after vacation, any date, Lordship.
After vacation. 23rd.
May please, Your Lordship. Lordship, I beg to mention for listing of a writ petition for motion, madam, on 1st of April, madam.
Why?
The urgency is that,
What
madam,
urgency?
the petitioners are 9 in number, madam. They are working under the health department for the past 12 to 13 years, madam. Now, madam, the government has sought to remove them, madam, without any notice and without paying our area salaries from the month of May 24, madam.
Let it be on 2nd of On a motion,
My
day.
lord, notification has already been issued on 18th, my lord. Therefore, I
All
pay
right, first.
obligement.
May I please, Your Lordship? I beg to mention item number 28, my lord, joint pair, my lord.
20?
28, Lordship. And for the reach petitioner, his my lord, opposite party, Lordship. Today, my lord, some difficulty I pay for next week, my lord, there is a next urgency, Lordship.
28 may defer to be listed after 2 weeks.
My lordship, it is a long pending case. May I request your
28.
lordship?
You are referring to item 28.
Yes, joint pair.
So next Wednesday, if your lordship may kindly
Next
be,
Wednesday, 2nd. Next week, Wednesday. All
Yes,
right.
Lord, second. Possible.
Right. A joint request matter be deferred to be listed on 2nd, item 28.
Yes, Lordship. Highly blessed.
may I please your lordship? But item number 9, item number 5, my lord.
Hmm?
Item number 5. We have filed an original affidavit yesterday, my lord. That may be called for one.
Let it come next week.
But there is some urgency, my lord.
If there's urgency, why did you file it today or yesterday?
But only the rule had been filed, my lord.
Let it come next week.
But then, my lord, let me argue the case on the listing. Let me argue the case, my lord.
All right.
May I please your lordship, I beg to mention item number 60. Respondent recently filed affidavit in opposition. We need 2 weeks time to file our reply.
Item number
60.
60.
60.
Item 60 stands deferred to be listed again after 3 weeks. Okay.
Please, your lordship, I beg to mention for listing lordship, any day before vacation lordship,
What matter?
service matter lordship, service matter lordship, service
Service matter.
lordship.
For what purpose you want to list? For admission, motion,
Yes, lordship, admission.
admission. 28th of April.
Before vacation lordship.
You said any date? Before vacation. Before vacation, have it on 4th? 4th of April.
Kindly send. Actually, my senior is not.
You give me your dates, I'll fix a date convenient for you.
Lordship, is my senior is not.
Yes. What date is good for you?
Lordship, kindly 10 lordship. 10.
10.
Yes.
All right. 10. Not 10. 10 is a hearing day. You can have it on 9th or 11th.
9 lordship.
9th. 9th.
Please, your lordship, I'd like to mention item number 29, lordship. Kindly matter may be withdraw, lordship. Petition already got relief, lordship. Retirement benefits.
You are for the petitioner, your name?
J. Ghosh on behalf of SC Vishwas.
MSJ Ghosh, counsel appearing for the petitioner on instruction submits that the petitioner does not wish to press the petition any further. Accordingly, the same may be withdrawn, permitted to be withdrawn. Prayer made is not objected to by counsel appearing for PNRD Finance AG by the respondents. Writ petition accordingly stands dismissed on withdrawal. Interim order, if any, stands vacated. Yes.
Oblige, lordship.
May I please, Lord? And the motion matter, maybe my lord, on 2nd of April, my lord.
Why?
2nd of April.
Why?
My lord,
What is the urgency?
My lord,
New matter, old matter?
New matter, my lord.
New matter?
Yes.
Then why is it not listed?
My
When
lord,
did you file it?
No, it was listed on last Friday, my lord. But wrong bench it was listed, my lord.
Second.
My please, your lordship. But one hearing matter, any hearing date may be given.
One hearing matter
For
will have to
listing.
be listed for orders first, then to be fixed for hearing.
My lord, it is hearing matter. Hearing matter.
You can't list, you can't mention for listing for a hearing matter.
My
You have to mention it for admission or orders.
Oh, my lord.
So let it be for orders. On
Before vacation, my lord, any date. My lord.
before vacation.
Any date.
4th of April for orders.
Oblige.
Yes.
May I please, madam? The challenge is to transfer order of the petitioner. Initially, my lord, she was transferred, but she finds at page, my lord, 21, the original transfer order, page 20, my lord, where she was transferred to by order dated 19/2/2024, she was transferred from serial number 1 from Group Center Guwahati to 232 Mahila Battalion. On an approach to this court, Lordship would find an order starts at page 21 at page 24 if Lordship has the relevant portion. Her mother is suffering from mental disability and therefore at page 24, my lord, after going through the condition of the mother, this honorable court was pleased to grant an interim stay. They modified the transfer order at page 26, cancelling her allotment to 232 Battalion, allowing her to stay back. Thereafter, Lordship would find at page 31, the repetition was closed. At page 32 is the relevant portion, taking into consideration the submission made by the learned counsel for the parties in view of the cancellation of the impugned transfer order. Now, my lord, few days later, another order at page 34 was a promotion order where petitioner's name finds place at page number 35, serial number 1810. On her promotion to an ASI, she has again been allotted the same 232 Mahila Battalion. The condition of the mother, Lordship would find
She's transferred on promotion.
on promotion now.
Earlier it was not on
It
promotion.
was a regular summer chain transfer, what they call. Now, if Lordship has page 46, the disability certificate of the mother certifying 50% disability at page 46, and an opinion of the doctor, Lordship would find from their own doctor. Lordship has page 46, the last line, percentage of disability, moderate person disability 50%. Their own doctor at page 50, Lordship would find it is the doctor of the Central Reserve Police Force. The last two lines, impaired immediate and recent memory. What happens is she is losing her memory, she cannot recognize things. At page 50, Lordship will find the last two, the last, second last line, impaired immediate and recent memory. This was given at page 51 by the psychiatrist of the CRPF. Then Lordship would like to have page 53, the third paragraph from the top, the opinion of the doctor. The patient does not sleep, significant memory loss, aggressive outbursts, then cannot take care of her own personal care and hygiene, requiring constant care and vigilance from her daughter, who is the only lone caretaker of the mother. Other children have deserted the patient. It is certified that this dementic patient should be kept in her own house, which is little familiar to her and which is necessary for her walking. Now, Lordship would have the office memorandums which deal with this situation at page 58. Is the office memorandum of 2024. Lordship may like to have page 60 of that. Clause I. Clause I, Roman 1. A government employee who is the caregiver of a dependent daughter, son, parents, spouse, brother, sister with specified disability, as certified by the certifying authority as a person with benchmark disability, as defined under section so and so of the Right of Person with Disability Act, may be exempted from the routine exercise of transfer or rotational transfer subject to administrative constraints. When this matter was moved on the first day, my lord, a query fell from this honorable court whether for retention and to take care of her mother, the petitioner would go to the extent of foregoing her promotions if necessary. I have filed an affidavit, my lord, an additional affidavit to that effect. Well, my lord, I have taken the specific stand that, my lord, I would be ready to forego all service benefits, provided I am allowed to stay here with my mother for her care. During this intermittent time, my lord, the petitioner had tried to adjust her mother with relatives, with friends, with in the hospital, everywhere. Nothing works. She gets up at 2 in the night. The mother goes to answer nature's call. She has to be given a bath thereafter, and then only she would come back to bed. It is impossible for the petitioner to leave her mother at this age. And the office memorandums say that a caretaker has to stay back, and the right of persons with disabilities also provide for the same. Initially, a stay being granted, withdrawn on the basis that it was cancelled.
The difficulty is, my lord, the petitioner has already taken over the rank of assistant ASI. And moreover, my lord, on the last routine transfer, my lord, 1 year period was already considered under compassionate grant, my lord. And now, my lord, that medical illness of the mother can persist for years, my lord. So cannot be retained for unlimited period. That is the
So you decide on this issue. You say that the rules don't permit or anything like that.
my lord. That's
You have to decide on this issue.
so, my lord, I'll get the instruction. My lord.
You get instructions or we permit him to file proper representations
My lord.
with proper references.
In fact, even prior to this transfer order or when they were on the verge of cancelling my earlier transfer, if Lordship finds it page 33, even then I had made a request that please retain me in any case.
No.
And moreover, my
That
lord,
earlier proceeding has come to an end because
Yes,
of the
that is-
withdrawal or cancellation. Now, instead of waiting and giving you, because to get instructions, we'll have to stay.
otherwise, my lord, the place where she is posted, my lord, is have medical facilities, and already we have
That will
taken.
never be denied, but with a person with mental disability,
It's not on that.
70-year-old,
It's not on that.
75-year-old.
My lord,
It's in terms of the circular,
my lord.
which is
My
there.
lord, yes, my lord. Page 61, my lord. Yes, Lordship may kindly come to page 61, second paragraph. The term specified disability as defined here is applicable as grounds only for purpose of seeking exemption from by a government employee who is a caregiver.
That is what I was.
You have already
Parents.
taken over
For
promotion.
routine transfer. This is a promotional transfer.
You have already taken charges in terms of the promotion.
My lord, on the transfer order itself, Lordship will find there are several people of
No,
my
but
center also.
if they withdraw the transfer order, they may withdraw your promotion also.
That is what, my lord, I have filed an affidavit to that effect that I am ready, even for a reversion, I am ready. I cannot leave my mother is the only situation. I am ready for a reversion. And I will not go back on
So
it.
let the department take a call, my lord, and get instruction.
You want to take instructions or we dispose it off? You consider the case on the basis of whatever representation you filed, and you pass an order. Until then, the order will be kept in a bin. Mr. Mazumdar?
Yes. At this stage.
Ar- Mr. R. Mazumdar, then it comes. Mr. Tegu, then it's CGC for the respondent. Petitioner before this court has put to challenge the order dated 31/01/2025 issued by the respondent authority, whereby the petitioner was transferred on promotion to 232 within bracket M Battalion CRPF. So, petitioner is serving as assistant sub-inspector at the group center, Central Reserve Police Force 1. Earlier, the petitioner was sought to be transferred to the same battalion by same battalion, and the petitioner approached this court by filing a writ petition urging that the petitioner's mother needs constant medical care as she is suffering from dementia,
Dementia and Alzheimer's.
Alzheimer's, and the petitioner being the only caregiver, she cannot. Her mother cannot be left alone without constant care and supervision by the caregiver, namely the petitioner. So, initially, there was an interim order passed by order. Give us the order, earlier order.
That starts at page 21, order dated 5/6/24 at page 22. Relevant
Order
portion is
dated
at page
5/6/2024.
24.
Subsequently, the earlier transfer orders stood cancelled, and consequently, the writ petitions stood closed by order dated 24/1/2025. Stop. Para. After the earlier order was cancelled, the present deputed order was issued, whereby the petitioner was transferred to the same battalion, but on promotion to the post of FT, Inspector General.
No, to the post of assistant sub-inspector of ASI. She was head constable earlier, now she has become an ASI.
as ASI, Assistant Sub Inspector at Group Senate, Assistant Sub Inspector. So, but you said it was transfer and promotion.
Yes, my lord. She was head constable when she first approached this court. The repetition having been
So
withdrawn,
then how do you say you are serving as assistant in sub inspector
they've
without
given me the rank, my lord.
they given you?
They've given me the rank officially.
The petitioner submits that the respondent authority has gone back to the earlier transfer, but with the only difference of giving her a promotion on transfer. She has already been given the rank of assistant sub inspector with the CRPF. Stop. Counsel to the petitioner has referred to several medical records of her mother, of the mother of the petitioner, given by specialist doctors to submit that the petitioner's mother suffers from Alzheimer's, dementic Alzheimer's. And as per doctor's advice, as per medical advice, she is required to be retained in her present place of domicile or residence, so that she is familiar with the surroundings. So, under such circumstances, the petitioner has approached this court. Counsel for the petitioner has also referred to the policy of the CRPF on circulated by a circular office memorandum dated 2nd of February 2024. So, he refers to clause capital I that caregiver of person with disability dependents are exempted from routine transfer / rotational transfer. So, he submits that this present transfer, although shown to be a transfer on promotion, is a routine is in the nature of a routine transfer, as the petitioner was earlier transferred as a head constable to the same battalion to which he has now been transferred, but on promotion. So, Mr. Pegu, learned CGC, submits that he be permitted time to complete his instructions. So, having heard learned counsel for the parties and on careful
Also, one submission, my lord, regarding that policy, my lord. It's regarding routine transfer, but this is a promotional transfer, my lord.
Mr. Pegu submits that the policy which has been referred to by the in the OM dated 2nd of February 2024 is in respect of routine transfer / rotational transfer, but by the impugned order, the writ petitioner has been given transfer on promotion, and she has already accepted the rank. Mr. Petitioner provided, Mr. Mazumdar further submits that the petitioner has also filed an additional affidavit to state before the court that she is willing to forego her promotion to stay back and look after her disabled mother, as there is no other person or sibling willing to take care of her mother. Having heard learned counsel for the parties and upon careful consideration of the submissions made, as well as the circular as well as the office memorandum referred to. This court is of the view that since there is already a policy in place for exemption of from routine or rotational transfer in respect of a person who's the caregiver, disability dependent, comma, this court considers it appropriate to close the matter at this stage, permitting the petitioner to file representation immediately with all particulars before the
My lord, it will be addressed to the respondent number 2,
address
but
will
we'll
be
go through the respondent number 5. The authorities, respondent number 2, the Director General has to take a decision. Official process requires it to go through respondent number 5 with this.
but then it will take a long time.
Well, I submitted, they sent it by electronic mail or with their comments on the doctor report. That is why it goes to the
direction go to direction,
Let me get to respondent number 5.
Respondent 5.
Five.
He
Maybe can
sent
it
to
be
the
director
respondent
general?
number 5 before the respondent number 5, who in turn will examine the matter in the light of the OM dated 2nd February 2024, along with the medical opinion rendered by specialist doctors who are certifying that movement of the disabled mother, the petitioner, from her present place of residence would be detrimental to her health.
Director General is to do PHA 5.
The
Director to be PHA connected.
respondent number 5
To number
will
2.
consider the application to pass appropriate orders. Within how much time do you require? 3 weeks? 3 weeks? Within 3 weeks from the date of receipt of the application. Petitioner is permitted to file the application within 1 week. Within 1 week from the date of receipt of a certified copy of this order. A copy of this order will also be filed before the competent authority. Till the matter is decided by the respondent number 5, the impugned order dated so and so, which order?
31 5 at page 34.
34, 31, 1, 2025. Insofar as it relates to the petitioner, whose name appears at serial number 1810, shall remain state.
Well, it has to be respondent number 2 because the transfer, the promotion is by respondent number 2. The lower authority would not be able to decide.
You say the application be filed to the respondent number 2,
Thank you.
the office of the respondent number 5, to the respondent number 5, and thereafter the respondent will decide on his pass necessary orders. The respondents will also take into consideration the contention of the petitioner that she is willing to forego her promotion.
I'm obliged.
Disposed of.
Obliged.
Yeah, please, your lordship. Lordship, the petitioner who was working as GIS assistant under Circle Officer Doboka, lordship, on contractual basis, his service was sought to be has actually been terminated on oral orders. While lordship, the project under which he was working, Mission Vasundhara, is still continuing. And other similarly situated employees, lordship, about 96 are there all over in the state of Assam. They are still continuing. So on the last occasion, lordship, the respondent sought for time to seek instruction by order dated 7/3/25.
Yes.
And
my lord, revenue. Revenue.
My lord,
putting away.
we have already that my lord will issue this matter, but no instruction has come. My lord will issue notice, my lord, because he is not in service. From 11/3/24, he has nothing to show. It's now 1 year that he is in service.
Yes.
So my lord will issue notice, we will respond, my lord.
Corollary to that is, Lordship, they have nothing to show, Lordship, that I have been terminated.
My lord,
That is also there.
No, no, my
No
lord.
order has been issued till now.
My lord, it is not that I have nothing
So
to
I
show.
am in a
That is the
bona fide
thing in
manner I am
notice, my lord.
submitting, Lordship. Bona fide manner I am submitting in the
Are you working in the office?
No, Lord.
Then
Lordship, in the advertisement, it has been mentioned that
we'll examine it. We'll examine it.
My lord will just.
We'll examine it.
But
Your
if-
claim is that you are not terminated and you are also not allowed to work.
My lord will just.
verbally they have asked me not to come anymore.
Are you there going to the office?
No.
Then you're not holding the post.
Only one difficulty, Lordship. By order at page 32, the project Mission Basundhara has now been under extension till 31st of March. My instruction is that, Lordship, this will continue further. This will continue further.
For
So,
what reasons you were asked not to come?
actually, for a period of 9 days, 8 days, Lordship, for my father's treatment, I was not attending office. I returned and I continued. They allowed me to continue, I continued. But suddenly on a particular day, they asked me that you need not come anymore.
We will let him file his affidavit or whatever he wants to file.
I'm under assumption that maybe that is the reason.
We are issuing notice at this stage. Third learned counsel for the issue notice. Return for 4 weeks. Mr. R for appears for respondent number 4 and 5. Mr. J. Hendig appears for respondent 1, 2, 3. Since the counsel represent the respondent, notices are waived. Extra copies be furnished within a period of.
Extra copy given, Lordship, already.
Extra copies.
Extra copy, one copy I have received. He will
Extra copies.
I'll give you.
Notice is
furnished
not
within
issued.
a
How can he
period
give?
of 1 week from today.
As per last order.
Counsel says he is not received.
I'll give Lordship. And endeavor maybe made early disposal.
Let them first come back with some information.
Obliged.
Here, your lordship, I was directed to get instructions, but I received one WT message yesterday that they had received it only on the whole repetition and everything on 17th. So they are taking some more time. 1 week time may be granted.
Yes.
Your Lordship, he was placed under suspension and
So he's praying for time. Is there any objection at this stage?
Just 1 week, your lordship.
next week, Lordship.
All right. Heard.
Next Friday.
Next
Counsel
Friday.
for the parties. The counsel for the respondent, Mr. D. Bora, prays for further time. As agreed to by both counsels, matter be listed on 4th.
4th, your lordship.
4th April.
4th April, Lordship. Obliged.
May it please your lordship. Junior assistant, my lord, was terminated. They were asked to obtain.
Last occasion, I was asked to obtain instruction. My
19.
instruction is there, my lord, on the 2nd of April, my lord, that departmental proceeding, my lord, hearing is going on.
My lord,
So
I am
held
not,
on the 7th.
my lord, I am not on the hearing. The issue is during pending of a statutory appeal, my lord, I found a document which was.
And even that documents, lordship, we are asked to, my lord, the sub-register to produce the original one. And on that day, it will be verified. But that application was not rejected as per my lord, that instruction.
So, my lord, that observation will be there that they will not reject my application and they will consider.
They wanted to verify the original one. Lord.
My
That's
only
why,
prayer
lord,
is.
it was on the 2nd of April, my lord, it has been fixed.
So this is
A document which was filed during the pendency of the appeal. I filed a separate application along with that document. My only prayer is that to consider that document, nothing more.
well, you will consider it after verifying.
After verifying.
No, that.
The prayer of the writ petitioner in the present proceeding is that pursuant to his dismissal from service by the departmental proceeding, petitioner had filed. This is a statutory appeal.
Statutory.
Filed a statutory appeal on 28/10/2024 before the respondent number 1. Stop during the course of the proceedings before the appellate authority, petitioner filed an application for
Dated 20.
placing dated 25/8/2024. No. Which order you want? What is that order?
25/8/2022.
What order?
My lord, that was a document where my senior in the post directed that is at page 32, my
All
lord.
right. The petitioner wanted to place an departmental order.
Departmental order.
Departmental order dated 25/8/2024.
22.
Huh?
25/8/2022.
Page number?
32.
33.
Original 33, type copy 32.
25/8/2022. Issued by the senior sub registrar. Which he wanted to place to the appellate authority by way of the application file. So, since the application was not considered, he has approached his court praying for appropriate orders. Stop. This court on by the last order permitted the counsel for the respondent to obtain instructions. Stop today when the matter is called up. Mr. A. Hendick, learned standing counsel revenue, submits that the matter is under consideration and the department has called for the relevant records to verify.
Verify that letter dated 25/8/2022.
The verify the
Page 30.
Authenticity.
For the purposes of verification of the communication / order dated 25 August 2022 submitted before the appellate court by the petitioner. It is submitted that once the verification process is complete, necessary orders will be passed by the appellate authority. And therefore, the apprehension of the petitioner that his application, that the documents placed before the court will not be, before the appellate authority will not be considered is belied. Where a counsel for the petitioner submits, if that statement is recorded, then he has no further cause to pursue in the present petition. So accordingly, in view of the submissions made by the standing counsel that the communication and order dated 22/5/2022 sought to be placed by the petitioner before the appellate authority by his application filed is in the process of being verified by comparison with the original record by the appellate authority. Consequent thereto, appropriate orders, if called for, will be passed by the appellate authority. The same, the petitioner, having expressed his satisfaction, counsel for the petitioner having accepted the submissions made that the application is under consideration, submits that there is no further cause to pursue in the writ petition. Accordingly, the writ petition stands disposed in terms of the above. Any order that is passed on the said application shall be served on the writ petition. And it is expected that the appellate authority will dispose of the appeal expeditiously as per the provisions of law.
Obliged.
Obliged.
May I please the lordship? This is a case for condoning the upper age limit, my lord. So, my lord, if your lordship see at annexure 2.
You want some affidavit to be filed?
But that is the rule, my lord. On the last occasion, the court made an inquiry regarding under which rule this was published.
So bring it when next week. Let it be next week, Monday or Tuesday, Tuesday or Wednesday. Wednesday, Tuesday.
Not Tuesday.
Let it be Wednesday because today is the last working day of the week.
But actually, what happened, my lord, this, my lord, the online procedure has been closed. That is the problem.
Whatever it may be, let Let it be, let all your papers, if you have filed, have you filed it or you want to file it?
I filed it.
You have filed it. You have filed it. Counsel for the petitioner, Mr. S.P. Das, submits that an additional affidavit has been filed to bring on record the relevant rules under which the steps are being taken against the writ petitioner. Stop. The counsel for the respondent, Mr. P. Sharma, submits that he has been served with a copy of the affidavit.
Yes.
Stop.
Personnel department was not served.
You have the rules, their rules from your department? No.
No, it's my department.
You serve him a copy.
I'll submit.
Let the matter be, since the affidavit is not on record, let the matter be taken on. Second, there is free to trace out the affidavit stated to have been filed with the petitioner and connect it to the case record before the next date fixed. Mr. D. Vora appears for respondent 5.
Highly object.
May I please your lordship?
Issue notice.
Yes.
Noted.
Yes. Mr. B. Kessler and Mr. J. Payang for
Respondent number 1, 3, and 5, 4, madam.
1,
3, and 4.
1, 3, and 4. And Mr. A. Chalia for respondent number 2. Issue notice returnable 4 weeks. Since the councils are represented, notices are waived, however, extra copies be furnished within a.
Mallet only annexure I, Mallet, the one representation is pending, Mallet. Annexure I, page 36, Mallet. Let them consider.
Pendency of the writ petition shall not be a bar to consider and dispose of the representation stated to have been filed by the petitioner before the concerned authority. ID.
Commissioner Secretary, Government of. Respondent number 1.
Before the respondent number 1, ID notification, representation dated 9/11/2024. Stop. Writ petition be listed after the returnable date.
Alright.
Notice.
That's it. Engaged counsel is on the legs at code number 3. So maybe kindly pass over for the time being. Also, let it be heard by the engaged counsel.
Monday, Tuesday?
Yes, sir. Tuesday I shall not be able.
After some time.
All right.
Yeah.
My please, Lord. In this case, my lord, petitioners applied for the post of Anganati helper, my lord. Pursuant to advertisement dated 11/12/2024. And accordingly, interview was held, my lord.
Get your instructions.
No, my lord. I need to take instruction.
That's right. Get your instruction.
Yes.
Mr. A. Hussain appears for the petitioner. Mr. S.R. Rava appears for respondents. Respondent number
3, 4, 5.
3, 4, 5, 6, 7. And Mr. R. Dhor for 1 and 2.
1.
No, 1 is Boroland.
1 is border, madam.
Oh, yes, madam.
Yeah,
I will appear
Mr.
for
Rava for 1, 3, 4, 5, 6, 7. Mr. Dhor for respondent number 2. Let the respondent counsel complete their instructions in the matter. Counsel for petitioner will ensure service of extra copies within 1 week from today. Matter be listed after 3 weeks.
Yes.
Well, pendency shall not be bar on the part of the respondent.
Pendency shall not be a bar or the part of the respondents to
consider
the case of the petition.
Obviously.
Yeah.
Well, the petitioners are retired section officer and assistant section officer of the Assam Agriculture University. Grievance is that, my lord, although the 7th pay commission recommended for NS pay from 1/1/2016, but implemented from 13.
Yes.
20. Notice may be issued. I'll get my instruction.
Heard. counsel for the party issue notice returnable 4 weeks.
Well,
MS
representations are pending, that may be, pendency shall not be filed.
So if you want a disposal for representation, we can dispose it off.
Well, then notice.
You are appearing for
Assam Agricultural University.
appearing for all the respondents.
All
1,
except
2, 3,
6,
4,
Your
5.
Lordship.
Mr. Tolia for respondent 6. Since notice respondents appear, notices are waived, extra copies be furnished, matter be listed after the returnable date. It is made clear that pendency of the writ petition shall not be a bar to consider and dispose of the representations filed by the list after returnable date.
Deeply obliged.
Obliged, Your Lordship.
May I please, Your Lordship. My lord, here in this case, Lordship, I was suspended on 9th October 2023, Lordship, 9/10/2023, Lordship. As I was arrested by the ACB Police, Lordship. Subsequently, Lordship, although the charges were framed, Lordship, but my suspension was not reviewed, which is mandatory, Lordship, as per on judgment of Honorable Apex Court as well as Division Bench of this Honorable Court, Lordship.
Yes.
Well, Departmental proceeding has completed, Malad. Now I think the second show cause is issued. So in the let it be after 2 weeks, Malad, I will obtain the instruction.
My lord, a date may kindly be fixed. Because law is very much clear, Lordship, otherwise. It is required to be reviewed.
Respondents are represented by Mr. T. Sutia. C. Sutia. Appearing for respondent number 1
and 2.
1 and 2. Who submits that departmental proceedings have been concluded. He however, prays for time to complete his instructions in the matter. There are matter be listed after 2 weeks, permitting Mr. Sutia to complete his instructions and apprise the court. The counsel for the petitioner will serve extra copies within 1 week from today.
Obliged.
List again after 2 weeks.
On 9th, Lordship, kindly, Lordship.
Not 9. 28th.
Obliged.
May it please your lordship. The matter relates to the non-consideration of the case of the petitioner for promotion, your lordship. May I take your lordship to page number 34?
You are seeking what? Promotion?
Promotion to the post of.
You'll issue notice here.
Yes,
Third learned counsel for the party issue notice. Mr. Hor.
All
Appears
men.
for
I'm appearing for all men.
for all.
All men.
Since the respondents are represented, notices are waived. Extra copies be furnished within 2 weeks from today. Respondents may complete their instructions and file necessary affidavit in the matter.
May I only pay your
Matter be
lordship? There
listed
is a
after
post.
returnable date.
There is a post vacant, your lordship. A post may kindly be kept vacant, your lordship. Or STP candidate. I'm a STP candidate.
How many candidates? How many writ petitioners?
Only one. Only one.
My lord.
Let the instructions be. Without finding out what is the position may not be proper.
Yes, yes. I'm deeply obliged.
Maybe. My lord, earlier one writ petition was filed, my lord, on 21/3/2025. An order was passed by this honorable court fixing the date on 7th of, my lord, April, asking them to produce the list of ineligible candidates who have been enlisted in the list of candidates to be allowed to be appeared for the departmental examination. And on the same date, my lord, having come to know about the initiation of the court case, my lord, they have issued the impugned order, fixing the date on the eve of the 7th, on 6th, for departmental examination, so that it can be completed before that, my lord. And whereas, my lord, I have annexed the list, Annexer 6C, ineligible, my lord, candidates. Total 104 numbers of candidates who are not qualified as per the existing service rule. It is required the graduation. And my lord, total 198 numbers of candidates in the list, my lord, who are above 45 years of age. And my lord, a total 146 numbers of candidates are there in the list who are above 50 years of age.
What is your prayer now?
My prayer is to my lord, stay the my lord impugned order, my lord.
Which order? Which order?
My lord, impugned order that dated 21/3/2025.
Page number.
Page number. It is page number 95.
95.
Yes, sir.
Yes.
Existing service, statutory service will be there. I have annexed, my lord.
What is this? This is
the
departmental written test.
Yes, fixing the date of examination on 6th of April, my lord. Whereas this honorable court has given the direction the earlier occasion to produce the list of eligible candidates on 7th.
What difference does it make?
Because, my lord, we have been out from the list, my lord. Ineligible candidates, retired persons have been included in the list, my lord. We are eligible, qualified persons. We have been.
You prepone the matter if you want. We can advise you what you should do.
Our case is, my lord, we should be included in the.
Both the matters should be taken together, list it on. We'll have it on 2nd.
Yes,
It's not third, my lord. Well, the region is also there, my lord. I will point out, my lord.
Whatever it may be,
Yes,
let it be on
we have
2nd.
good reasons, my lord, for that.
Why not 2nd?
My lord, yes, I will have to seek the instruction they are going to find. Let it be second, yes. First, somehow, my lord, the first is again closed, my lord. I will.
Why will first be closed?
Well, because of heat and all, my lord, it
Likely
may,
to be closed.
Might be.
We have communicated the earlier
Because
case.
I will press the instruction, my lord. Otherwise, I've got telephoning instruction. So why, my lord, all these persons have been included? There is a policy decision to that effect, my lord. And that policy is not under challenge in the present petition or in the earlier. I place it, my lord. Let it be on 2nd, my lord.
As per the Supreme Court guideline, my lord.
My lord, only thing, my lord, he will serve a copy to me, my lord, by within the first half, so that I can.
I am giving the right now, my lord.
Heard learned counsel for the parties submitted that petitioner that earlier approached this court and has filed the writ petition putting to challenge the decision of the department to proceed for only departmental written examination by including candidates who, according to the petitioner, are not eligible. So, this process has resulted in the petitioners being excluded from the list of eligible candidates who are required to appear for the departmental written examination, and which examination is necessary for further consequential departmental promotion.
Right.
So, this was brought up before this court in WPC.
WPC 1542 of 2025.
1542 of 2025. So, the respondents are represented by Mr. P. Goy, and a petitioner lately appearing for all the instruments. Considering that a writ petition is pending, let this writ petition be listed on 2nd.
Let me on 3rd, my lord. Otherwise, also, my lord, the moment examination is held, it's not that, my lord, they will be promoted.
All right, on 3rd.
If we are not allowed to, my lord, participate in the examination, my lord.
Prepare, your examination is on which date?
6th.
6th. You start preparing.
Yes.
On 3rd, you'll get to know whether you will be allowed to appear or not.
Yes.
List this matter again on 3rd. Only this matter. We are not directing the other matter to be listed. It's fixed on 7th, isn't it?
It may come along with that or my.
No, we can't direct it. There is already an order.
Yes.
We are only listing this matter, allowing him to get the instruction.
Yes, on 3rd.
On 3rd. It's on 3rd.
Obligation.
Yeah, please, Your Lordship. Lordship, this matter pertains to transfer and posting of the petitioner. Petitioner is presently serving as a pioneer in and employed with the border roads. So this is the second time petitioner has approached this honorable court. Previously, the petitioner has approached this honorable court, and this honorable court by judgment and order dated 13/2/25 has directed the respondent authorities
to dispose of the representation of the petitioner. I'll take your lordship to page number 70. Relevant portion is at page number 74. May I read, your lordship? Paragraph 4.
Yeah.
Upon hearing the parties and on perusal of the materials available on record, this court find the request letter was initiated by the petitioner on 30/8/24, but however, same could not be considered in terms of what the petitioner has stated regarding his 50% permanent disability. The respondent authorities appears to have rejected the application on the ground that his transfer and posting order has already been issued. However, the same is not the case since the petitioner application was submitted on 30/8/24. Considering the fact that the
It
petitioner
was directed to be considered.
Yes.
Then what happened?
Thereafter, what happened? We have submitted the representation and a speaking order was passed, which is as page number 86. The relevant portion is at page number 88. In this speaking order, lordship, the respondent authority have stated that since this is there are multiple grounds which have been taken by the authorities, but the first ground which they have stated is that since the previous transfer was on compassionate ground, so this time we cannot give him a subsequent transfer on the same ground. Thereafter, they have relied upon a notification stating that that on the notification which states that employees who are declared to be benchmark disability not less than 40% specified disability duly certified or are sole caregiver or dependent person with disability may be considered on station where medical, educational and facilities connected are available on rotational basis subject to administrative consent. They further stated that the clause may also represent the possibility and it's not obligatory. The third point, which is stated by them, is that the hospital there are sufficient hospitals available in the place where they have been posted. And thereafter, on the last portion, which is at page number 88B, they have stated that there is a co-coding. Accordingly,
You have to
petitioner.
examine this matter. You get your instructions, Mr. Dr. Get your instructions here.
My lord, I have already examined all aspects and passed the speaking order. But there is no provision, but
You are a person with disability.
Yeah, 50% locomotive disability. And I'll take your lordship.
Where are you posted now?
Presently, I'm posted Tezpur.
Tezpur. And where have you been transferred?
Jammu and Kashmir. Your Honor, this honorable court on
In what post?
Pioneer. It's a grade 3 post.
Grade 3 post.
Yes, and previously on my disability started in Jammu and Kashmir, lordship. And this honorable court taken into consideration this fact that my disability started from that place of origin. So thereafter, they remanded back the matter to be considered on merit. And one more aspect.
What is the difficulty you face? You perceive?
There are employability restrictions. I'll take your lordship to page number. Page number 46. Annexure 4. Page number 45 is annexure 4. Relevant portion is page number 46. I have been categorized medical category. The first para. I have been categorized as grade 3 P3 permanent disability with effect from 25 July 24. Now the next page in the code coding, it has been specifically stated that I am unfit for high altitude and extremely cold climate.
Where?
In the next page, page 47. Thereafter, I may not be able to tolerate extreme exertion. I'll take your lordship to page number 134. This is the ROI of the respondent authorities.
134.
134. The category grade 3. Physical capacity P3 has moderate disablement with limited.
Where is the transfer order?
Transfer order is at transfer. 54, page number 54. This is a type portion. The original transfer is ordered, page number 55. The first.
This transfer order was issued on.
Yes, thereafter I have approached this honorable court. This honorable court has directed me to submit a request.
When was the order? When was your representation disposed of? By which order?
By order, page number. My representation was disposed of by annexure 16, page 86.
86.
Yes.
Right, third, General Counsel for parties issued notice. Mr. Dr. appears for
All the respondents.
all the respondents. As such, office is the way, however, extra copies be furnished within a period of 2 weeks of the date. Petitioner claims to be a person with disability of locomotor disability of 50%. And is and it is contended that he is unfit to serve in high altitude. Petitioner was earlier in Jammu and Kashmir, subsequent to his disability, which he acquired during his service, was transferred to Guwahati. Guwahati. Where were you? Where are you posted? Tejpur.
Tejpur.
Posted in Tejpur. Stop. Subsequent thereto, he was again sought to be transferred to Jammu and Kashmir, because of which he approached his court earlier by filing the PPC number 744/2025, which came to be disposed of on 13/2/2025, directing the petitioner, the respondents, to examine the matter and pass a speaking order. Stop. Pursuant to the directions issued, the case of the petitioner was examined. However, its claim was rejected, because of which is before the court by filing the present proceeding. Stop. The counsel for the petitioner has referred the restrictions applicable to the petitioner because of his disability and submits that he is not fit for high altitude duty, and the place where he is being sought to be transferred is admittedly a high altitude station. So, Mr. He therefore submits that the transfer order be interfered with, and till the matter is disposed of, adequate interim order will be issued. So, Mr. Dr. Learned Counsel, representing the respondent, submits that the matter was examined in depth, and thereafter the respondent have passed the order sustaining the transfer order issued earlier to the manufacturer. So, having heard learned counsel for the party, let the matter, let notice issued in the doctor, having accepted notice on behalf of may complete his instructions and file necessary affidavit, and taking into consideration the submissions made, till the next 8 weeks status quo on respect of the transfer order we maintained placed on 28th of April. Nothing.
Petition. I have limited grievances, my lord. The petitioner father died in harness in the year 2013 while serving as lineman in APDCL, my lord. Thereafter, duly filled up form has been endorsed and certified by the departmental authorities. And ultimately, page 24, the authorities of Chief Executive Officer North Lakhimpur Electrical Circle APDCL has submitted the requisite proposal before the Chief General Manager APDCL Bijuli Bhavan. That in the year 2020. Till that, my lord, no decision has been taken.
Submitted in 2020.
Yes, my lord.
Get your instructions.
7 years.
Heard the counsel for respondent will obtain his instructions in the matter. Your name?
B. Das.
Mr. B. Das, appearing representing all.
Except one.
Representing two
One is
people,
open.
5. Mr. CKS Borua appears for respondent number 1. Extra copies be furnished within 1 week from today. Let the respondents complete their instructions, then
That may
may
be
file necessary affidavit to advise. The meantime.
if possible. That may be date, my lord.
Date?
Yes.
Uh, 30
Hello.
April.
Petitioner is agreed with the suspension order. He is a junior assistant. Now attached to the office of the inspector of boiler Silchar. But the suspension, he has been placed under suspension by the respondent number 3, who is not the competent authority to place him under suspension.
Well, get instructions there.
Lordship, may issue notice that
Why? You get your instructions, whether reviewed or not, at least that part you can get it.
reviewed, it has been reviewed.
It has been reviewed, but he is not the competent authority. Rule 6 does not permit.
Get the instruction. Why? He's an employee of what? Labor. Any departmental proceedings initiated?
Yes, shock cause notice issued by the respondent number 3. He is holding the post of the in charge chief inspector of boiler, and his appointing authority is chief inspector of boiler. And rule 12 of the boilers rule says that no one shall after 2 months temporary posting will not be allowed. And another is that when his in charge posting was given to him.
Right, heard and counsel for parties should be extended about 4 weeks. Mr. Bora, D. Bora appeared for all the respondents. As such notices are waived, extra copies will be furnished within a period of 1 week. Placed after returnable.
Respondent number 3, my lord, by name I have him.
By name?
Yes, because I have Alice Melapai.
Then 1 and 2. Notice on respondent 3. Steps by registered post 80. And usual course.
Date may be because he is under suspension, my lord, for long.
After service of notice, you have arrayed him as a party, you'll have to serve notice.
Yes, I will have, but the date may be on 29th or 30th April.
After returnable date? After returnable? You want to take dusty on respondent 3?
My lord, I will register post.
If you had taken a dusty, we could have given you a returnable date.
But he is at Silchar now. Right.
After returnable date?
And that, because my lord, he is a suspension and facing the.
You make a mention if we have given you 4 weeks, if it is not listed, after 4 weeks, you make a mention. Yes.
The matter pertains to compassionate appointment, Your Lord.
Yes.
The petitioner is
Yes,
recommended by the
compassion.
DLC.
Why are you not showing compassion?
Lord.
Why you are showing too much of compassion?
My lord, compassion could be shown.
What has happened to those writ
certain cases?
What has happened to the writ?
That is again fixed for 3rd, my lord. 3rd of April, my lord. My lord, here is a case.
We'll issue notice here.
His father died in 2006. So, my lord, what compassion we can have, my lord? Supreme Court didn't show any compassion, my lord.
We'll issue notice, you get your instructions. Heard and counsel for parties. Returnable 6 weeks. Mr. M.S. Sharma appears for respondent number 1. 1, 4, and 6. Mr. R. Thor appears for 2 and 3. Since the counsel represent the respondent, notices are waived, extra copies will be furnished within a period of 1 week from today. List after returnable date.
Be listed with 5067, Your Lord.
No, my lord, not taking, my lord. Let it come first.
Let it come.
A similar matter.
Similar matter, all right. Same respondent. Same respondent.
Yes, sir.
All right. So 17, 18, 19, 20.
19.
20?
Yes, 20.
All right. Up to 20. Keep notice.
Suddenly such cases are cropping up, my lord. All 20 years.
Your Lordship, all are recommended by DLC, Your Lord.
We'll examine.
The petitioner's promotion to the rank of Subedar was due in 2024. The TPC, however, did not consider his name. Upon representation, my lord, it is revealed that uncommunicated ACR, my lord, was taken into account. And that is the reason, my lord, why promotion was not considered, my lord.
Yes, Mr.
Yes, also there is, you get that basically it happens also when the ACR is not up to the mark, that
You get your instructions, we not issue notice at least. Heard and counsel to the party. Counsel preparing for the respondent, Mr. CK will complete his instructions in the matter. You are appearing as CGC.
CGC also.
CGC will complete his instructions in the matter. For which extra copies be furnished within a period of 1 week. Matter be listed after 3 weeks.
Possible.
Right. Yes.
Wait, please, Your Lordship. Lordship, in this case, I have been serving as helper in this Anganwadi center since 2016. And what happened, Lordship, is since 2018, I have not been paid my area monthly honorarium. I have approached the authorities several times, both verbally and through representations, for payment of release of my area honorarium and regularization of my post. And each time they have verbally given me assurances that I may be allowed to, I may continue and they will make arrangements for the payment. Meanwhile,
Get
suddenly,
your instructions here.
my lord, in the meantime, my interim prayers may be,
What interim prayer?
my lord, my humble prayer is that I may be allowed to continue because of this impugned advertisement. They have issued this impugned advertisement against my helper post. So
Have
I
you
may be,
challenged the advertisement? Have you challenged the advertisement?
yes, my lord, I have challenged the advertisement. The impugned advertisement is in page number, my lord, 32, my lord. And also they have given a criteria that the applicants may not be more than 44 years of age as on 1st January 2025, and I have already crossed that. I have served
Yeah,
in
how
this.
soon can you get your instruction? Third?
Meanwhile, my lord, till then status quo may be maintained. I may be allowed to continue.
Counsel for the petitioner. Mr. D. Bora appears for all the respondents. Petitioner is aggrieved that she is not allowed to continue in her post as what? Anganwadi helper.
Helper, my lord.
Helper.
Helper.
In which Anganwadi center?
In 437 number, Paschim Kalbari Anganwadi Center under Morigaon.
37 number Anganwadi. Paschim Kalbari Anganwadi Center under
Purbandha ICTS
Bondha
project.
ICS project, Morigaon, since the year 2016. Petitioner is aggrieved that without proper justification, she was not allowed to work, and now the department has proceeded to advertise post for fresh employment. Advertise the post in which she was working for fresh recruitments. So, aggrieved, she has approached this court. Let the respondents complete their instructions in the meantime. Matter be fixed, considering the urgency expressed, matter be fixed on 3rd of April. The prayer for interim to be considered on the next date.
My lord, till then status quo, till 3rd status quo, my lord, this much.
How are you benefited? How are you benefited? You are not working.
I'm working, my
You're
lord.
working.
Till date, I am still working. I have
Alright,
not
then
been
we
terminated.
then we'll say that without leave of the court, petitioner shall not be released.
Let me get the instructions, Your Lordship, because
My
that is
lord,
what
without
she has
leave of the
stated.
court, the petition may
Otherwise,
not
she has
be.
not been getting any honorarium since 2018.
But I have been working. I have been
Since-
regularly going.
Lordship, let me just
My lord.
complete. Let me complete. Since
Better we
2018.
keep the interim order available on
Third, Your Lordship,
third.
Your Lordship will consider.
You can renew your prayer on 3rd.
My lord, without the leave of the court, at least till the next returnable day. Small indulgence, my lord. Small indulgence.
Let the prayer for interim will be considered on the next date fixed. Next date, 3rd. 3rd of April. You
Madam,
renew
till
your
then,
prayer
at
on the
least let me
basis
be allowed to continue till then, because I am continuing in the service, my lord. I have not
your
been terminated.
continuing in service is disputed by the respondents. Let the instructions be placed from their records as to whether you are continuing, not continuing, what is the place. Only then we can give you some interim order. Otherwise, what is the point in giving you interim order without the clear facts? If
Yes,
you
my
are
lord,
not
I
getting
understand.
salaries, when are you not getting your?
2018, I have been approaching, my lord, there are
No, no,
representations.
when was the last time you got your salary?
2017 December.
17 December. Is it logical that anybody will work for the next 8 years without salary?
My lord, I have been going.
Why will you work?
My lord,
Why
actually,
will you
it's
work
not
unless
able
you
to
are paid your
perpetuate.
salary? Why have you waited for all these years to?
Yes, my lord, because they have been giving us assurances, because I have been
So
visiting.
you take your assurances. Keep on receiving the assurances for 8 years.
My lord, it's a bona fide legitimate expectation, my
8
lord.
years.
My lord, yes, I understand and I agree to
You
that.
should be grateful that we are entertaining your petition
Right, my
after a delay of 8 years.
Yes, my lord, I
Press your
understand
luck
that.
too far.
But at least
Let it be on 3rd. 3rd.
small observation, my lord. Till 3rd, I may not be released without the leave
No,
of
no,
the
no.
court.
You are not released today.
No, no, I
Then why
have
are
not
you
been
apprehending
released.
you'll be released on
I'm
3rd?
afraid that I'm apprehensive
You
because.
come back again, we'll take care of that on 3rd.
Yes, my lord.
Sorry, madam. I was on late.
I need to take contractual lordship.
Well, initially, as per comparative statements, I was selected. But while Lordship may kindly see the annexure at annexure 7, page 35, my lord. Page 35, Lordship kindly see serial number 7 is the respondent and serial number 9 is the present petitioner. Lordship may kindly see remarks column. Respondent number 7. She is a regular student of IYDE Academy, Tihu, BA first semester, date of admission, so and so. And so far the petitioner is concerned, her residence is nearest to the AWC, though she is second in merit position, but selected. The first position candidate, that is the respondent, she is a regular student. So, my lord, one of the conditions that candidate should be a resident of that area, and she must not be a regular student of any course. So that was the condition for for applying, my lord. So, my lord, here respondent was a regular candidate, so that is why I was selected. But while, my lord, the final select list was prepared, Lordship may kindly come to page 37, annexure 8.
Yes.
Serial number 3. Serial number 3, Mitali Das, she is the respondent, my lord. Remarks is that highest marks in HSLC amongst the candidate and suitable for the post. So accordingly, right minutes, annexure 9, page 38. This final select list was forwarded, and subsequently, annexure 9, page 39. Her select list was approved. So, that is what petitioner is before your lordship, my lord.
But this is in December 22.
My lord?
December 2022. Minutes.
Yes, my lord.
22 December.
No, my lord.
Really?
Minutes, my lord, but that is, my lord, there may be some, my lord, typographical error in the minutes. Because, my lord, I have mentioned it is that SIC, my lord, SIC.
If not 2022, then it must be 23. Look at the signature. 23.
That is true, my lord. But if your lordship kindly come to the contents, my lord.
Whatever it may be, so we'll
I shall take
instruction. When?
Friday, lordship.
Friday.
Friday. Friday, lord.
Heard Senate Council for the parties, the Council for PTC,
Yes, lord.
MSRB Bora, submits that she would like to complete her instructions. As agreed to, matter be by both councils, matter be listed on 4th. And council appearing for PTC will be served with extra copies during the course of the day.
Well,
can you do it? In course of the day. List accordingly. On 4th.
appeals, Your Lordship. My lord, as per order dated 29/1/2024 in case number IS Civil 3797/2023, I communicated, my lord, to the director, Veterinary Department, Ashok Kumar Burman, SCS, Director of Animal Husbandry, to for implement the case in Stapar. It is my communication letter, my dated 24/2024. It is paid before Your Lordship. Therefore, Ashok Kumar Burman may be implemented.
Kumar Bormon,
Ashok Kumar,
who is he?
he is Director of Animal Husbandry and Veterinary, Assam, Khanapara, Guwahati, 78.
IAS. Huh? Who's the- Have you filed your amended post title?
Huh?
Amended post title.
Eminent petition filed, and as per order ISC bill, the contributions are closed and give me liberty to communicate the letter for leg him party, Ashok Kumar Burman. It is my letter.
No, in the writ petition, we don't find his name. Ashok Kumar Bormon name is not here. You have to file amended post title before the registry. By which order the implement was completed?
As per the order dated 29/1/2024.
In view of order dated 29/1/2024, passed in IA 3797/2023.
I communicate this letter.
The petitioner was permitted to intimate the concerned official, namely Sri Ashok Kumar Bormon ACS, who is presently serving as the Director, Animal Husbandry and Veterinary, Assam, Khanapara, by communication dated has been permitted to communicate, intimate, the petitioner by communication dated 2004/2024. The counsel for the petitioner has submitted the has submitted an application, a copy of which is placed before the court. Submitted a communication dated 2004/2024, along with all enclosures, which is placed before the court. Of the said application, however, does not contain any endorsement by the concerned officer. Who's for the veterinary department? Since the council stated to be representing the veterinary department, MSM Kotobi, is not present in court. This court requests the government counsel available in court, namely Sri D. Bora, to complete his instructions from the concerned officials who are arrayed as parties as to why the directions contained in the order dated 6/12/2017, passed in WPC 7521 of 2017, has not been complied with. For the purposes of completing his instructions, can you serve him an extra copy? Can you serve him an extra copy of the writ petition? Counsel for the petitioner will serve extra copies of the writ petition, the learned government advocate, within 1 week from today. The government advocate will complete his instructions in the matter and apprise the court. Matter be listed again on 1st of May, 2nd of May, 2nd May.
Is that?
2nd
May. 2nd May.
So item number 23, this is regarding payment of an arrear salary of 59,000. Here we have received that in this coming financial year, we'll make the payment, Lordship. We have brought it to the notice of the respondent authorities, Lordship. We are assisting the court in this matter, Lordship. And in the next level, so Lordship may fix it immediately after the Bihu vacation, Lordship. In the meantime, I have an instruction, Lord.
The none appears for the petitioner on call, Mr.
Solia for the health department, Lord.
Jolia, learned counsel representing the respondent, submits that the department is processing the claims of the
Yes,
petitioner, and
Arrears
within the
salary.
month of April, there is every likelihood of the dues being cleared.
Yes, Lordship. In the
In
next,
respect of the petitioner. In this context, he has placed a copy of the communication received by the council, which is placed before the court and kept in the case report. Matter be listed from the month of May.
Lordship.
None appears for the petitioner, pass over. Same order. Is it complied?
The issue here is that difference in the date of birth, Your Lordship. Most of the parties have complied with Your Lordship. We have rejected representation.
None appears, pass over. Mr. R.R. Bora appears for the
R.R. Gogoi, Your Lordship.
R.R. Gogoi appears for the respondent.
All right.
May I please, Lord? Lordship, High Court order is in page number 31, Your Lordship. Lordship, in this item, Lordship, I'm seeking 2 weeks time here. Basically, there was a representation made by the petitioners to consider them for regularization, Lordship. And I was asked to assist the court. Lordship, if I can just get a copy of the petition, I will immediately after the vacation, Lordship, I can just get a status.
You have not been given a copy.
Lordship,
Copy has been served, Lordship.
no, Lordship, Lordship, if I can get another extra copy because none of the parties are holding office right now. It's only.
Can you give him an extra copy of the
Lordship,
contempt petition? Today?
Today, Lordship.
Not possible.
Tomorrow, Lordship.
Tomorrow, Saturday. Tuesday, I can, Lordship, Tuesday.
Mr. A. Chaliha, counsel for the respondent, submits that his instructions are not complete. He raised for accommodation for 2 weeks.
Lordship.
Counsel for the petitioner, Mr.
P. Chakraborty.
P. Chakraborty appears for the petitioner. Mr. Choliha has also requested for extra copy of the contempt petition with enclosure. Counsel for the petitioner submits. He will ensure service within a period of 1 week from today.
My lord,
I need the communication copy of only one in my hand. I will next give this code.
Is a Kakor representation.
Malad.
Yes.
Not complied with my
Not complied.
partly complied with my.
Who's for the respondent? Anyone for the respondents? None has appeared.
Yes.
For fresh steps, you've been asked to take fresh steps.
Yes.
Did not receive. You did not take fresh steps. Office note says counsel for petitioner will take fresh steps as permitted by the court earlier. In view of the office note dated 25/3/2025, that fresh steps were not taken. And will be listed after 4 weeks.
Lordship, in this matter, we have not received our instruction, Your Lordship. Lordship, kindly sometimes may be given to file our affidavit, Your Lordship.
Pending since 2023.
23.
But Lordship, after motion, it has come for today, Lordship.
Who gave you that idea that it must come for 10 times before you were complete your instruction?
Lordship, on that
Have you
time,
seen the last order?
Lordship,
2023.
Lordship, on that
And
time,
you are
Lordship, we
waiting
have,
for the matter to be called up by the court. It is the court's fault that you are not getting the instructions.
no, Lordship, but we have communicated our department, Your Lordship.
Then we'll call for the officers who are there. Why have they not furnished you instruction? Let them be present with all relevant records.
Lordship, kindly 2 weeks time may be given, Lordship. We will take instruction.
It appears the department is not communicating with you. So let us find out why they are not communicating. Who is there? From whom are you required to get instruction?
Lordship,
Which officer did you communicate?
Lordship, PLOD Commissioner, Lordship.
Commissioner. Why is the commissioner not responding?
Lordship, they are responding, but it has took some time, Lordship. Lordship, kindly sometimes may be given, Lordship, because
You get instructions by 2 o'clock, or otherwise we are getting your commissioner to the court.
Lordship, can you Wednesday, Your Lordship?
Today, 2 p.m. You have 1 hour. Get your instructions from your commissioner. Why the instructions have not come from 2023? If you had communicated with the department,
Lordship.
do it.
Lordship.
Otherwise, we are getting your commissioner in court today. Yes. Hold it up at 2 p.m. Go affidavit file.
Lordship, some instruction received, Lordship, but I'll fix the matter after 2 weeks, Lordship. I will file that.
None appears for petitioner. Matter stands referred to be listed after 2 weeks. Mr. A.K. Goswami appears for the rest.
Make withdrawal. My lord, in person to an order passed on the last occasion, we have communicated the order passed by my lord to Honorable Justice Maheshwari, my lord. And recently, my lord, yesterday I received a communication, my lord, wherein he has expressed some reservations, my lord. So I'm just placing that order, my lord.
Hey, notification on you. Pursuant to the earlier order dated 5/3/2025, the prospective arbitrator, Justice Dinesh Maheshwari, former Judge, Supreme Court of India, has expressed his difficulties uh, mm, in deciding the matter as an arbitrator, sole arbitrator. Stop. A copy of the communication dated March 26, 2025 is addressed to the Registrar General of Guwahati High Court. Stop. Under such circumstances, since this court had already appointed an arbitrator, a fresh order is required to be passed for appointing a fresh arbitrator in the matter.
My lord, my friend and we have come to a consensus if it is not inconvenient for my lord. Honorable Justice from Guwahati would be convenient, any judge sitting there from Guwahati.
Uh, in view of the regrets expressed by the prospective arbitrator, Justice Dinesh Maheshwari, reported that in the communication dated communication dated 26 March 2025, taking into account the nature of dispute and likely valuation, whereby he has declined his prospective appointment so that the parties may not be put to unnecessary expenditure, within bracket particularly on logistics concerning these matters, as these matters appear to be comparatively of lesser valuation. Let Mr. H.N. Sharma, former judge of the Guwahati High Court, be appointed as an arbitrator to decide, arbitrate and decide on the disputes and differences arising out of the work referred to in the order, order to decide for work and implementation. Stop. Let a copy of the written declaration of the prospective arbitrator now appointed by this order, namely namely Mr. Justice H.N. Sharma, retired H.N. Sharma, former judge, Guwahati High Court. We communicated this order by the registry as well as by the parties, and a written order to that effect, written declaration by the prospective arbitrator, Justice so-and-so, be placed before the court by the next date fixed.
We highly obliged.
In both the matters. Matter be listed again on on 5th of May.
My lord. My lord. Obliged, my lord. Highly obliged. Okay. Lordship 35 is similar. 35 is similar matter. 33, 34.
Similar matter.
Lordship.
33, 34, 35.
Lordship. Must oblige.
3 matters. He has rejected he has declined in all the 3 matters.
My lord, in all the 3 matters, he has given a common, my lord, the communication.
That's what I am asking
yes,
you.
My lord, yes,
decline.
In all the 3 matters. I'm obliged, my lord.
Declaration, my lord, sir, I have given on record. Declaration by the proposed arbitrator.
In view of the earlier order dated 5/3/2025, written Mr. Justice H.N. Sharma, former judge, Guwahati High Court, was appointed as prospective arbitrator by this court. to decide on the disputes between the parties arising out of the agreement executed by and between the parties dated 15/2/2016, a written declaration by the learned prospective arbitrator dated 8th of March 2025 is placed before the court. Accordingly, the appointment of the prospective arbitrator, Justice H.N. Sharma, former judge, Guwahati High Court, hereby stands confirmed. So, Justice H.N. Sharma, former judge, Guwahati High Court, will act as the sole arbitrator to decide to arbitrate and decide the disputes between the parties executed by and between the agreement dated 15/2/2016 and render the award as per provision of law. So, a copy of this order be furnished by the registry to the learned arbitrator appointed. The parties are also directed to appear before the learned arbitrator on
My lords, 10th of April, my lords. 10th of April.
10th of April. 10th of April. And a copy of this certified copy of this order be also placed before the learned arbitrator. Order according disposed.
My lords, there's a order in the IA, my lords. Some interim protection is needed, my lord, until Section 17 application is decided by the learned arbitrator.
In the IA, you write status quo order. A copy of this you reflect the arbitration. In the IA, by order passed in the IA 3578, status quo in respect of transfer sought to be made in the property specified was directed to be maintained till the next returnable date. So, counsel for the petitioner submits that the status quo order be directed to be maintained until further orders. In considering that this court has already appointed an arbitrator and the parties are directed to appear before the learned arbitrator on 10th of April, the status quo order will continue till 10th of April.
My lords, may I request, my lords, 90 days is mentioned in section 2, my lords, of 9, subsection 2 of 9.
So you file a proper application.
I will file, my lords. So let it be, my lords, till section 17 is decided by the learned arbitrator, my lords. Because till section 17 application, we will move section 17 application.
You move before the arbitrator. You move it on
10th of.
And get an order if the arbitrator feels like.
Please, ma'am. Please.
The petitioner is permitted to move appropriate application under the provision of the Arbitration and Conciliation Act for extension of before the arbitrator for extension of the interim order, if so advised.
Please, ma'am.
This vote.
Please, Your Lordship. My lord, in this case, my lord, my prayer was very limited. That, my lord, I had applied to two categories of post, my lord, revenue solicitor and administrative assistant, long back, my lord, in the year 2022, my lord.
Yes,
Correspondent may
the
kindly be-
instructions.
Lordship,
One copy of the instructions I have provided. The thing is that Lordship, the file, Lordship, the record cannot be traced at the office, Lordship. And the searching has been going on, Lordship. In the meantime,
we have written to the government for extension of period time, Lordship. And accordingly, Lordship, as the original file remains untraceable, the process has not been initiated and currently is on hold. Therefore, Lordship, both the proposed has been remained vacant, Lordship. We have not done anything with it, as the record is missing.
And this was earlier submission, my lord, made by the earlier other council, my lord. My prayer before your lordship, my lord, is that my lordship will kindly direct the my lord, district commissioner, my lord, to fill up the post lawfully, my lord. That is my humble prayer, my lord. This petition is pending since the very beginning of
That is our intention. That is the only reason we have kept
several
the
occasions, my lord, this
vacant.
case has been.
No, but is it necessary to issue a direction that it has to be as per law? It has to be as per law.
Yes, ma'am.
Then why that direction is necessary?
But they are not filling up the post.
Because
They are not filling up as then when they'll fill up, they'll fill up. Or if you want to contest the matter, let them file their affidavit, we'll see what
But
happens.
they have not filed, my lord. Several occasions, my lord, the case was listed, my lord. Now they are saying that the file is are not traceable, my lord.
Notice heard learned counsel for parties notice in the matter was issued by the court on 24/1/2024. Respondents have not filed their affidavit till date. A copy of the instructions have been placed before the court to submit that the concerned file is not traceable in the office of the Deputy Commissioner Morrigaon. So, since be that as it may, since the notice is issued, matter be listed for admission hearing on on 8th of May. The respondents may file their affidavit if so advised in
My lord, my retirement benefit is not paid yet.
My lord, I got instructions from the municipal authority that they have only after this institution of this writ petition, they have paid only rupees 20,000 on 3rd of October 2024, and the rest is an admitted amount. And because of their scarcity in the funds, they could not be unable to pay. And
You have to arrange for it. You can
My
deny
lord,
it.
some other petitioner, my lord, earlier approached my lord, and they accommodated it. This order, my lord, I may be allowed to pay.
That is on a what do you want?
My lord, they arranged some other petitioner. So my lord, in my case, they arranged also, my lord. So that was.
You arranged.
But the scenario is that I have asked for this their income and expenditure statement.
Whose income expenditure?
This municipal board's expenditure.
No, but this is another order where they have released all the payment.
Yes, this is that order was 22 of 2022.
No,
Now the present scenario, yes, that they have paid, no dispute about that. But if for the year 2023 to 2024, they are running in deficit of 40 lakhs. Last page. So little,
You
they
bring
need
it on
some
record.
time because
You bring it on record if there's anything you want to submit. Bring it on record.
They need some time. They will pay.
Mr. Richa Chaudhary for the petitioner, Mr. or A. Dhor for the respondents.
Four.
Respondents?
Four.
Four and five.
4 and 5.
4 and 5. Mr. Dhor submits that the petition, the respondent municipality is suffering extreme financial crunch stop. Although they have sent proposals to higher authorities for release of funds, the same has not yet been done. He submits that further time be granted to the respondents to arrange for the funds or payment to the petitioner. List in
Well, May.
May,
On April, last week of April, my lord.
19 May.
Obliged. May I take back the original?
Yes, yes. Take back.
Obliged.
Like, in the meantime, they may arrange, my lord, 19 May.
Definitely,
That's
we'll,
what
we'll
we
try
said.
to arrange.
They will arrange.
My lord.
We're not against her.
Here, your lordship, some more time may be given. Because we have sought the instructions, but we have not received the instructions. as
It's
to
a matter with the DLC and SLC, both of them have recommended the case. It's pending the finance department.
How much time?
Lordship, after a Bihu vacation, so lordship, immediately after
Bihu. Yes, Mr. Dotto. Mr. Dotto appears for the petitioner. Mr. D. Bora, counsel for the respondent, submits that his instructions are awaited. Waits for further time. Based on 28th April.
Obliged, lordship. Highly obliged.
May it please the lordship, on the last occasion, the council had obtained instructions, but they have not filed a affidavit.
Yes, Mr.
In
Borwa.
42, lordship, we have filed affidavit in 42. We have also filed affidavit in 43. And in 44 also we have filed affidavit.
In 43 and 44 claims are completed.
Yes, yes.
In fact, in
41, I think we have not filed affidavit, but the issue is same.
All right. The councils have, the parties have exchanged pleadings, matter be listed for admission. Then we'll issue rule here.
Your lordship, let it come up in admission. It's a very small issue.
What is the small issue?
The issue is that, your lordship, I have been penalized for refusing promotion, which is in violation of the statutory law. The rule does not prescribe the imposing punishment for refusing the promotion.
Well, let matter be listed for admission hearing the month of May on a date to be fixed by the registry.
41, they have filed their affidavit.
They don't file. They say it is similar.
Similar. Just that she was transferred, then she was attached to some other.
We'll keep it on the next day if they file. The
During
council
pendency
for
of
the
the-
respondents may file their affidavit in WPC number 58 of 2025 if so advised.
Lordship, there is an interim protection law.
The interim order, if any, will continue. Yeah.
First time was debarred by the respondent by passing impugn order.
Are you filing anything?
Your lordship, we have not received instruction yet. Instruction is awaited.
There was an interim prayer, Millard, for staying of that impugn order, Millard, and the order reflected that on returnable will be considered. So can you consider that?
Your lordship, I am appearing on behalf of the respondent number 5. Otherwise, this writ petition will not be maintainable in view of the fact that the marriage has already been dissolved between the petitioner and the employee of the APDCL. So this is the
petitioner
and the employee of the APDCL, the husband.
What is the name?
Name of the husband is
Surendra.
Surendra
But he expired.
Rajkumar. He has expired, but before that, long back in the year 1985, the marriage was dissolved.
By way of?
By way of compromise decree of the court.
Will you bring it on record?
Yes, I'll bring.
Let him bring it on record.
Yes. By the time you have interim order considered.
Huh?
Interim order may be considered.
No, your lordship, that
No,
cannot.
how can there be an interim order if the marriage is annulled?
No, my lord. This is the compromise has been, my lord, outside court, my lord, but not a divorce was given, my lord.
You said compromise decree or agreement?
No, my lord. The outside court is a settled, my lord.
No, no, no. There is a compromise decree passed by the Court of District Judge Lachar Silchar.
Good. You bring it on record.
And they have made an incorrect statement at para 6 of the
So bring it on
Yes,
record.
yes, I'll bring it.
Counsel for the respondent, Mr. S. Dotto submits that writ petition is not maintainable as the marriage of the petitioner with her late husband prior to his expiry is to be annulled by way of a compromise decree passed by
the learned District Judge Kachar Silchar.
passed by the learned district judge Kachar Silchar. Stop. He is permitted to bring these documents on record by way of an affidavit. Mr.
S. Sinha, my lord.
S. Sinha appears for the writ petitioner. Mr.
He Paul on behalf of KP.
C. Paul appears on behalf of respondent number
124.
124. Let the matter be listed after 4 weeks.
Obliged.
In that case, my lord, date may be fixed, my lord. Otherwise, my lord, she is 56 years later, my lord, he could not get anything, my lord. Otherwise, he is getting
30 May. 30 May.
Obliged.
13 May. Obliged.
Yeah, the matter relating to my lord pension.
We have not received the extra copies, my lord. That's because, my lord, we are not able to, my lord, take in
The extra copies, please
No, no.
furnish.
We have received it. Just
I furnished my lord.
some time may be granted.
One.
Further time is prayed for by the
Yes,
respondent.
Tini matter.
Also,
Seven.
counsel appearing for the Revenue Department submits that extra copies have not been received. Anything to submit? Counsel for Revenue as well as Principal Accountant General submits that extra copies have not been received. Para. Mr. R. Learned Counsel for the petitioner submits that extra copies will be furnished within 1 week.
Yes.
Within 1 week from today. The matter be listed thereafter. Matter be listed after 4 weeks, enabling the respondents to complete their instructions in the matter.
Obliged.
In this matter, I am appealing in item number 48, lordship. I'm sorry, I pray for legal accommodation, lordship. Affidavit in reply, ready, lordship, they could not come to sign the affidavit. So at least 7 days, lordship, I pray for it.
Yes.
I'm appearing in 47, lordship. In 47, I have filed affidavit in reply.
But both are connected.
Yes, both are connected.
So any objection to the prayer made?
No, no, lordship. Our interest is same in both.
Mr. Tobildar, A.R. Tobildar, Learned Counsel for the petitioner submits that
Sometime.
further time of 2 weeks.
2 weeks.
2 weeks be granted, enabling him to complete his enabling him to file the affidavit in reply. Prayer is not objected to by Mr. R. Dhor, appearing for the respondents, as well as by Mr. Purkashta, appearing for WPC 1475.
1475.
1475. Mr. Tobildar has appeared for WPC 1106.
110.
List accordingly after 3 weeks.
Obliged.
May I? Lord, in view of the affidavit in opposition filed by the respondent authorities, my lord, the matter can be disposed of. Since the matter is pending before the competent authority due to the non-clearance given by the District Commissioner Kokrajhar. If your lordship kindly see para 9 of their affidavit in opposition, my lord.
What is your grievance here?
Yes.
Affidavit
Non-payment of
not filed. Affidavit not filed.
Affidavit filed, my lord.
Filed.
We have checked up, my lord. Affidavit in opposition filed by respondent number 4 and 6, my lord. Lordship would file. There, para 9 lordship will file,
Pensionary benefit not released.
not released.
Why?
Because my lord,
Who
due
is
to
for
the
the
my lord,
union?
non-clearance given by the district commissioner of Kokrajhar.
Who is for the union?
Now, last occasion, my friend was there. SP Chaudhary was there.
Where is Mr. Chaudhary?
Can it be after some time, my lord, we will inform.
After some time.
I'm sorry, Mr. Item 48 interim order may be continued. I forgot.
Matter to interim order passed. Let me continue.
In item 48.
Thakur.
Item 48. Obligement.
Matter relates to prolonged suspension, 2.5 years, my lord. Without, they are under suspension, my lord, more than 2.5 years, my lord, without any proper periodical review, my lord, and departmental proceeding also.
Pleadings are complete.
Not complete. Okay. In fact, what happened is all the files were seized by the vigilance law. And accordingly, we are unable to continue with the departmental proceeding as well as preparation of the affidavit.
Then you have to reinstate him.
Now, Lordship, now court or department has already withdrawn the deferred order, Lordship. Earlier, Lordship.
Department has withdrawn the?
Earlier, Lordship, departmental proceeding against the petitioners were deferred for some time, Lordship. Now, that order has been withdrawn. New IOP has been appointed, Lordship. We have also issued reminder to the vigilance, Lordship, for
No, that's all right. But whether you have reviewed it prior to
yes,
expiry
that
of
has
90
also
days?
been done, Lordship. That has also been done, Lordship.
Where is the suspension order?
My lord, I have filed one additional affidavit, my lord, that recent one page 195, my lord. But that affidavit is filed on 26/3, my lord. Page 195. 195, my lord.
Yeah.
That order on 21/3/2025, my lord. Married, my lord.
Yes.
Whereas Sri so executive engineer under suspension, code number 7, Guwahati Municipal Corporation was placed under suspension with effect from 24/10/2022, higher order number so dated so due to serious allegations of misrepresentation of public fund and in connection to the vigilance police station case number so under section so. And whereas this executive engineer under suspension code number so Guwahati Corporation was served the memorandum of charges against which he had filed his reply and intended to inspect the relevant file as part of the examination of documents. However, the relevant file records were seized by the concerned official, Chief Minister Special Vigilance Cell Guwahati, Assam, in connection to the Vigilance Police Station case number 04 of 2022, and the same is still in the custody of the Vigilance Cell, concerned court having appropriate jurisdiction for ongoing investigation trial. In this regard, number of communications have been made with the concerned official, Chief Minister Special Vigilance Cell Guwahati, Assam, for getting back those file records, and the same is still under process. The period of suspension was reviewed periodically and further extended height office order number so dated 15/6/2023. In view of the above, and considering the gravity of the alleged offense, as well as charges framed by the investigating officer, Chief Minister Special Vigilance Cell, Government Assam, insert.
No, after you are being placed on suspension, when was it reviewed and extended?
Lordship, may kindly see the additional affidavit filed by the petitioner, Lordship. This is page 195.
Yes, I'm reading 195.
Yes, Lordship, may kindly see this is ordered is 21/3/2025. Lordship, may kindly see last but one paragraph, Lordship.
No. See the first paragraph. He was placed under suspension with effect from 24/1, 24/10.
Yes.
22. Then when was it extended?
Second paragraph, last two line, the period of suspension was reviewed periodically and further extended by the order number so and so dated 15/6/2023.
How can that be?
Then next paragraph, Lordship.
No, if the suspension is on 24/10/2022, How can the suspension be extended for the first time in 15/6/2023 is well beyond 90 days.
But lastly, Lordship, it was extended again on 21.
All these are irrelevant. The first extension has to be within 90 days, as per Deepak Mali and other judgment.
No, Deepak Mali will be different, Lordship. Deepak Mali in respect of CCS rules, Lordship. There, that provisions is there.
Yes, but you read that Rafet Ali judgment in between.
Rafet Ali. Lordship, in so that instruction I can take, Lordship. Whether it was done within 3 months period of law.
I of course the DMC, but state government has a notification that has to be reviewed within.
Others should already apply.
They apply.
Otherwise, it will apply everywhere. And my understanding is, Lordship, within 3 months period, you are required to issue the so-called notice. In this case, Lordship, vigilance has already filed. And thereafter, Lordship, I am required to pass one return order immediately.
Within 3 months, you are required to
review. For reviewing within 3 months, that 3 months period is not there. 3 months within which I have to issue him a so-called notice. Thereafter, I have to pass one return order extending his suspension immediately. The word immediately is used, but no time frame has been fixed. That is Ajay Chaudhary law.
So you get all these instructions there.
That one instruction only. After suspension,
two officers, my lord. Those are already been reinstated, my lord. Those are in.
We'll hear the matter.
They were under different department.
Maybe different, but they are on the deputy.
You get it when we'll fix it on a admission hearing.
Admission hearing,
when it is ready. Give us a date when you can get the instruction.
Time like vigilance reporting.
29.
29 lots possible.
29 April, my lord.
29.
Yes, my
All right.
My lord, for admission hearing, my lord.
Admission hearing. Matter be listed for admission hearing on 29th of April, as agreed to by the council for the parties. The respondents, meanwhile, are permitted to complete their instructions and also file affidavit if so. You have filed affidavit? No.
I have to file one.
My lord,
you file it.
Lordship, because files are not used. That is the only issue we are facing.
Permitted to file affidavit.
Lordship.
29.
29. Give it a key.
May your lordship kindly pass over this matter for the time being, your lordship. The senior went to the masjid.
54. Yes,
Kindly pass over the matter for the time being.
at 2 p.m.
Much of
I have some difficulty at 2 months.
All right, then let it come next week.
Your lordship, he went to the masjid for namaz. Kindly consider.
The last item.
We are sitting at 2 p.m. So come back at 2 p.m. You have some matter.
Personal.
Oh. Then let it come next week. Matters as agreed to, matter be listed on 2nd of April.
May it please, my lord. I filed one additional affidavit. Start at page 93. This honorable court even allow the as per the first order. If I want to bring certain important facts on record. May I?
Yes.
My lord, this is a transfer matter, my lord. I was posted in Golaghat there as a commandant, my lord. I was holding a field posting, my lord. Thereafter, my lord, I was transferred to Hyderabad, my lord.
No, are you praying for a disposal today?
No,
What is to be done?
My lord,
Readings are complete.
my lordship, I have been I have been asked to make a request for 2 weeks adjournment because the affidavit has been sent for waiting note.
My lord,
Then what is your, there's no interim order.
no interim order. However, my lord, this honorable court had indicated in the first order passed by this honorable court, 24-1 order, that it will be subject to order. Otherwise, there is no interim order.
So it will be subject to outcome.
My lord, may I kindly point out certain facts of my affidavit?
We are not hearing it today. Let them file their affidavit first. What orders do you want today? If you are pressing for some interim order, it's a different issue. But without, they're pressing for time. If you, do you object to the prayer made?
My lord, actually on the last occasion also my respected senior had taken time. If
So
my
we'll give
lord
him
would
one final opportunity.
My lord.
File it.
It may kindly be fixed.
Mr. P. R. Sharma for the petitioner, Mr. B. Chakraborty appears for the respondent. Mr. Chakraborty renews his prayer for further time to file affidavit in opposition. Mr. Sharma, on the other hand, submits that time had earlier been granted to the petition respondents to file, but the same could not be filed. Whereas considering the urgency expressed by the writ petitioner, let the matter be listed on 7th of May. 7th of May, by which date the petitioner respondents will file their necessary affidavit in the matter.
Deeply obliged.
Yes.
Legal lordship, can the matter be taken up after some time?
What is the issue here?
Lordship, they're claiming benefit under scheme. Lordship, please to see our affidavit.
No, what benefit?
Lordship, under listen. Notification 20 of 2007. Paragraph 5 of our affidavit is clear. They're claiming benefit under the scheme to which they are not entitled.
Take it up on some other day.
After being
Matter be listed for. Why is it before this? Is it partnered?
Lordship, earlier it was partnered,
Uh,
but every time my learned friend is taking time. When the
we'll release it from partnered. Matter be released from partnered to be listed before appropriate bench. After the PU holidays. Mr. Kyal appears for the respondents. Ms. So-and-so appears for the petition.
Lordship, my name may kindly be reflected in the court.
The registry will reflect the names of all counsels, including Mr. S.
Sorry, my lord, I was on left, my lord, when matter was called, my lord. My lord.
Nothing is there. Why? 2023 notice was issued.
Yes, my lord.
Then your assisting counsel informed that instructions have not come in by note. Writing letters, etc.
My lord, after issuance of notice, my lord, the districts were intimated, my lord. One reminder was also.
No, we are not asking you whether you have intimated or not. We are asking
Yes,
you
yes.
what are your
My
instructions.
lord, what happened, my lord? There are two, as per petitions, my lord, there were two districts, my lord. We have brought both the districts, but Morigao district said that the documents are with the Nagaon district, my lord. Now I have tried, my lord, to the concerned officer, my lord. Because of some health issues, my lord, he is not in a position to.
Your communications are dated 23.
Yes, my lord. From 23 itself, we are doing, my lord. Now at this stage, what is exactly there, that, my lord,
So we thought
or
we will
lordship may
call the officer
lordship
concerned.
may I suggest one thing, my lord. Lordship may dispose of the matter, my lord.
Hmm.
If verified, after verification, if they are eligible, my lord, we'll immediately within 2 months we will send the proposal.
No, no, no. You get your instructions properly. We fix it. You get proper instructions.
My lord,
here.
my lord, immediately after vacation, lordship may matter will be fixed, my lord. In the meantime, I will get the proper
23rd?
My lord.
23rd of April. Matter be listed on 23rd of April, enabling the learned counsel, the respondent to enter to complete his instructions and apprise the court. It is seen that notice was issued as far back as 23/6/2023, but no instructions are forthcoming. In the event instructions are not received by the respondent counsel, court may proceed to pass consequential order.
My lord.
Obliged.
That order may be kept in the record, my lord.
Which order?
I have letters mail.
We don't need this. This is for your. You are sought for information.
Yes, ma'am.
That's all. We don't need this.
My lord, my lord.
Take it.
I'll oblige, my lord. Item 49.
My I'm extremely sorry, Lordship. I was on leg in number 12, Lordship. Paragraph 9, my learned friend has shown it, Lordship. And on the last occasion also, I made a mention with regard to the fact that certain documents are not furnished. So in that view of the matter, Lordship, if he produces all these documents.
Which document?
Lordship, in paragraph 9, has been mentioned.
Of?
Affidavit in opposition, filed by respondent number 4 and 6. Page 59, para 9.
So what documents are necessary?
Oh.
Mr. Chaudhary?
Yes, Lordship. Basically, the genuineness of the petitioner's family pension, Lordship, marital status, and the legal status. So, if the petitioner can furnish that particular document with regard to legal status, marital status. If you Lordship kindly see the concerned paragraph, I'm just reading that particular line, Lordship.
9.
Yes.
Paragraph 9.
Paragraph 8, Lordship.
Paragraph 8.
Paragraph 8.
Paragraph
9. Paragraph 8.
Yes.
It is further submitted that on receipt of the copy of the present petition number such and such filed by the petitioner, complete service documents of the petitioner's husband belong to Army Ordnance Corporation records as well as Defense Security Corps records have been scrutinized and found that the petitioner's husband also married to Srimati such and such on 22/1972 as recorded in the service record belong to Defense Security Corps records. Therefore, as clarification regarding marriage of the applicant's husband with Srimati Koshwari Marag during lifetime of his first wife Srimati Sumutu was asked by Army Ordnance Corps records letter number such and such dated 22/7/2023, which is still awaited. Simultaneously, Army Ordnance Corps records by letter number such and such is also asked a detailed investigation from the District Collector Kokrajhar, Assam regarding marital status of the deceased soldier and legality of the marriage of the petitioner with deceased soldier for ascertaining genuineness of the petitioner's claim for family pension. But the same is still awaited. Hence, Army Ordnance Corps record is unable to process family pension. So this is the main inconvenience. We have not received any such communication from the concerned authority of the district collector. So the petitioner can obtain that document.
Petitioner is born out of the who is the mother of the petitioner? Who is the petitioner's mother?
Petitioner's mother.
You are claiming for what? Family pension.
Petitioner is the wife of the deceased employee.
Wife.
Wife. Two wives are there. And there are, it is revealed from the record, there are 3 wives. 3 wives.
3 wives.
Yes. First 2 wives already died, and petitioner is the only surviving wife.
First 2 wives have died.
We have annexed the death certificate. Lordship will find at page 48 and 49.
But the fact that you are a wife, how do you claim that? How do you, what documents you produce?
Now
in support of your contention that you are
yes,
the wife.
basically the NOC, my lord, that is, my lord, next of kin certificate, lordship will find at page 22. Page 22, my lord. Porendo Bushumatari, who was the husband of the petitioner, my lord. Page 23 is the, my lord, legal aids of the said Porendo Bushumatari. Number
Now
one, my lord.
you are asking for what documents?
Lordship, kindly see the page number 71. This is the annexure of the concerned authority.
Yes.
In this column is there, Lordship 1, 2, 3, and the next the 1. Srimati Samela Bushumatari has filed the subject petition in the Honorable Guwahati High Court at Guwahati bench claiming to be the wife of the deceased soldier and for grant of
No,
family pension.
you are reading from 71.
71. This, the right hand side, there's a column.
Affidavit in opposition.
In the affidavit in opposition.
Yes.
The 1, the number 1 is there, Lordship. 1, 2, 3, then 1. Srimati Samela Bushumatari has filed the subject writ petition in the Honorable Guwahati High Court at Guwahati bench, claiming to be the wife of the deceased soldier and for grant of family pension. And this office is unable to process family pension claim of Samela Bushumatari without knowing whereabouts of Srimati Somutu first wife and Srimati Such and Such second wife of deceased soldier, and also legality of third marriage with Srimati Samela Bushumatari. So this is the main inconvenience, Lordship. And
What
for which
information you require? You have been given this legal aid certificate. Sorry, the next of kin certificate.
next of kin is there, Lordship, but the whereabout of the first one, the second wife
How
is
will
also.
she know whereabout? Where will she find out?
Lordship, that is the reason why, Lordship, a communication has been sent to the district collector, Kukrajal. Lordship.
How will the
It is
collector
there,
find out?
it is there in page number 70.
How will the
Lordship.
collector find out?
Page 43 of the writ.
You issue notice. If
No,
required.
that has been issued, Lordship.
By
It is-
whom?
It is there in page number 70, Lordship.
We have given page 40.
43. This has been given. Marriage certificate.
Photocopy of death certificate, first wife.
This is given.
No, with regard to this aspect of the matter, Lordship, they have taken into account, and subsequent to that, there is another communication on 21st of August 2023.
Page number?
Lordship, this just now I referred to this particular page number 70, Lordship.
71.
70, Lordship.
70, yes.
Same thing.
How will they find out? It's not their job to find out. You are asking them to investigate and give information. Is it their job to go and find out who's married to whom?
That part
You
is
can
there.
ask for their. You can ask for whether any records are available in their office. You are asking them to investigate and
To
forward
submit report.
Huh?
And to submit report with regard to that.
Detailed investigation report. Who are you to tell them to investigate? They are not your subordinate employee.
Since, my lord, next of kin certificate has been issued by the competent authority, my lord, they can provide the, my lord, all pensionary benefits to the petitioner.
You have to take a call here. You have to take a call.
Based on this particular communication.
Whatever communication, you are asking for all and sundry to provide information as to whether person is alive or dead. It is for you to decide.
Only this is the inconvenience, Lordship, for releasing the family pension. Now, this
No,
particular.
what inconvenience? Somebody has come with what do you require? Is there a PPO? Where is the PPO? You get the PPO, find out whose name is there, get the service record. Will you have the service book or service record?
Let me get the confirmation, Lord.
When can you get it?
After vacation, Lordship, anyway. 23rd, 24th of April.
25th.
25th.
25th April?
April 25th.
Or 28th of April. Matter be listed on 28th of April, enabling the council appearing for, you are appearing for?
Yes, CGC, Lordship.
That is CGC, Mr. SP Authority. Procure necessary instructions regarding the service particulars of the petitioner, state husband, as well as the availability of pension payment order, if any. PPO will reflect who's the nominee. Is it there? No.
No, my lord, first, second wife since died, my lord.
That was
Petitioner was not the nominee, my lord.
It was not incorporated.
It might be the first wife, and he died, my lord, without leaving any legal heir. Second wife also died without any legal heir. Now, petitioner is the only, my lord, surviving wife who is having 3 children.
Let us see what happens.
Well,
Your Lordship, I appear for respond of 5.
5.
Obligation.
28. Yes.
May I please, Your Lordship? My Lord, in 54, I have instructions to withdraw the case.
54.
54.
Is submitted by the counsel to the petitioner that the petitioner does not wish to press the petition any further. Accordingly, the same stands from withdrawal. Mr. A. Sahiba against for the response.
My Lord, in 55, arbitration petition 32 to 24, Sharif Ahmed versus Dell Management and other. My Lord, here I'm seeking, in the other cases also, I'm seeking appointment of an arbitrator under a contract which was executed, Your Lordship, in connection with a project called APART, which stands for Assam Agribusiness and Rural Transformation Project. And the appointment of this particular person was made on 31st of May 2022.
Where is the agreement?
Agreement, Your Lordship will find at page 17, 17. 17.
आपने केस नंबर का चलने वाला गलत बताया है।
Sharif Ahmed 55.
ओके, हाँ। तो आपके तो
Kartik Balaji. My Lord, clause 18, the last clause at page 18, clause 18 is the arbitration clause. We understand and hereby agree that this contract, its meaning and interpretation, and the relations between the parties shall be governed by laws of India. We further understand and hereby agree that any dispute arising out of the contract which cannot be amicably settled between the parties shall be referred in adjudication, arbitration in accordance with Arbitration and Conciliation Act 1990.
Where is your notice?
My Lord, page 27, Your Lordship. Section 21, invocation of arbitration. Page 27, 25th June 2024.
Yes.
And thereafter, we even nominated an arbitrator. But my Lord, they have taken a curious stand. On one hand, they are saying there are no disputes. On the other hand, my Lord, they are also saying that amicable settlement was not tried. But the facts of the case are, my Lord, that the contract already stood terminated. They took a unilateral decision to terminate the contract, and that termination, in my respectful submission, Your Lordship, was in violation, clear violation of clause 5 of the contract, which says that the termination can happen only on account of unsatisfactory performance. And in fact, the termination notice itself acknowledges my good performance. And apart from that, even the decision that was taken by them, which they have enclosed with their reply, that is a unilateral decision. So all that, my lord, is in the realm of the dispute, which your lordship need not necessarily go into, but there is a clear dispute. In fact, even their response to my invocation, that itself shows that they are denying and disputing everything. The words dispute has been raised multiple times in their response.
Yes.
So admittedly, there is an arbitration clause, so it may be referred to an arbitrator.
Referred.
Right. And my lord, in terms of the notification, your lordship is well aware of 29. Only one from this panel may be elected as your lordship. Right.
Well, the amounts are not high, the nominal amounts they were. So some maybe retired district court.
It was
29. Mr. Your Mr.
A. Pukon.
A. Pukon. What is your full name?
Abir Pukon.
Abir. Counsel for the petitioner, Mr. You're also A. Saiwan.
AK Saiwan.
AK Saiwan. What is your full name?
Amit Kumar sir.
Amit. The petitioner before this court has filed his application under Section 11 of the and Conciliation Act 1996. So, petitioner was employed as consultant as the district enterprise development coordinator by the general by the district industrial. What is DICC?
It is actually, my lord,
District Industry and Commerce Center.
District Industrial
Commerce Center.
Kamrup. Pursuant to an agreement entered by and between the petitioner and the respondent by the agreement dated 31st May 2020. The terms and conditions, including the remuneration prescribed to be paid, are prescribed in the arbitration agreement. Clause 18 of the arbitration agreement provides that in the event of any disputes and differences which cannot be settled amicably between the parties, the same shall be referred for adjudication to arbitration. But this is a service contract.
This is a contractual appointment. Contractual appointment.
Contractual appointment.
And he was a consultant then.
Is it permissible to refer to arbitration in this kind of matter?
You know, this is the clause being there. I am actually, because this is an alternative remedy, I cannot even go to the writ court. By way of this clause, I am prevented from approaching even a writ court or even, my lord, the civil court.
Well, that question can be kept open before an arbitrator which we can agitate.
Pursuant to the engagement, the petitioner's appointments to terminated. By which order?
No, the termination was dated, your lordship, 6th of June 2024. They informed me of the termination.
Page number?
Your lordship will find that at page 26.
Was terminated by communication dated 31/5/2020.
So this is 6th June 2024. Your
Huh?
6th June,
Sorry,
page 26.
6th June
2024.
Being aggrieved, the petitioner represented before the authorities, which, however, did not came did not bear any fruitful result. Accordingly, he issued a notice under section 21, dated 25/6/2024, calling upon the respondents to refer the matter to arbitrator. Did you name any arbitrator here? Did you,
In my in this
the-
particular case, my lord, it was not sent, but in the subsequent cases, my lord, I had sent under section 11. I had nominated Justice B.K. Sharma, your lordship. But I leave it to your lordship to.
his name is not here.
But I leave it to your lordship to suggest.
You
I
want
mean,
a former judge of the High Court or?
no, I think, my lord, it is small amounts, nominal amounts. So I think from the
district judge.
in the district court itself. Amounts vary from 2-3 lakhs to around 14 lakhs in different cases. All the cases can go to the same arbitrator because it's similar issues.
However, no response was received from the respondent. So, counsel for the petitioner submits that since the notice was not replied to, right?
So there was a reply. There was a reply.
There was a reply.
On 20th of
Right.
July 24.
Pursuant to the notice issued, the respondents replied to the notice by communication dated 20th of July 2024, and
Disputed the allegations, most of the allegations.
while disputing the allegations made, did not concur in the appointment for an arbitrator. So, left with no alternative, the petitioner has approached this court under section 11 of the arbitration constitution. And pursuant to notice issued, the respondents have filed their objection. So, today, when the matter is called up for hearing the counsel for parties, this court is of the view that in view of the court is of the considered opinion that in view of the specific arbitration clause present in the agreement executed by and between the petition, being clause number 18, any dispute that has arisen between the petitioner and the respondent is required to be resolved through arbitration as per the procedure prescribed. The fact remains that petitioner stood released from the services which the petitioner claimed was not in terms of the agreement executed. Stop. The respondent denies the said contention. The further contention of the respondent is that this being a service matter. Is that your contention?
Yes, sir.
It being a service matter, the arbitration petition is not maintainable, or the matter cannot be referred to arbitration. So, having heard the learned counsel for the party, the number you consider submission made and the pleading consideration of the pleading made in court, as well as the provisions of the Arbitration and Conciliation Act 1996. This court is of the view that there exists a specific clause for arbitration in the event any dispute arises between the petitioner and the respondent relating to the agreement dated by and between them. So, several authorities are available as a pointer, fact that a referral court's power is only to examine the existence of a valid arbitration agreement. Thereafter, question of jurisdiction can be left open to be decided by arbitrator appointed. So, under such circumstances, this court will believe that an arbitrator is required to be appointed. So, from the notification dated 29, date number 29, dated 21st May 2024, by the Guwahati High Court, consider it appropriate to appoint, considering the value, considering the tentative value that may be quantified, that can be quantified in the contract, in the contract executed by and between the petitioner, which that can be quantified. So the petitioner, the court finds it appropriate, considers it appropriate to appoint. Tell us any choice? No.
I don't have the list.
Anyone, Mala?
ये तो if from High Court judge से लेंगे नहीं तो
You say the amount is not much.
हाँ तो district judge level में
Pradeep Kumar Das.
well no difference.
Pradeep Kumar Das as the arbitrator to decide the difference between disputes arising between the parties. Stop. Copy of this order be communicated with Pradeep Kumar Das, retired district judge, district and session judge, Assam, who is appointed as the who is the prospective arbitrator, sought to be appointed by the court, subject to a written declaration being furnished by the prospective arbitrator as required under section, as also required under the provisions of the arbitration law. Where the parties will appear, will communicate this order, the prospective arbitrator, Sri Pradeep Kumar Das, and upon receipt of the written declaration, as required under the provisions of the Act, the appointment can be confirmed on the next date. That was the listed, given the date.
The 2nd May. 2nd of May, you know.
2nd of state on 2nd of
All similar matters, my lord, only except
all the
item.
matters.
Only the contract dates will differ. The termination dates are the same. And the
Notices,
invocation notices also, we can cross-check and give it to the.
My lord, only in item 59, my lord. I think perhaps Lordship's order on 25/10/24, this matter stands abated.
59, actually, your lordship may defer the matter because yes, technically it has abated because the person actually, my instructions are that committed suicide. And after that, the wife also has gone through an accident because of which she is bedridden. So we will have to ultimately take steps. I know there's a delay and it may have abated.
Then this takes care of item number
59, my lord.
Up to 50, this is 59, which my friend mentioned, but 55 to 58 can be
54 is already not
withdrawn.
So 55 to 58.
Yes, those can be disposed in terms of your lordship.
55 to 58 disposed. 59 be segregated to be listed separately. Sorry, not disposed. Terms of 59 be segregated to be listed, or it can come on the same day. Why should we segregate it?
My lord, that is on 2nd May.
Yes.
Yes.
Then in 59 you write separately that it is submitted that the petitioner expired.
My lord, order at dated 25/10/24.
10.
25/10/24.
Since the petitioner had already expired, counsel for petitioner has prayed for taking necessary steps for substitution in the matter. Let the matter be also